Prudence Beaumont, and I'm a tenant at Dean's Court Chambers. I'm going to be talking to you today in my seminar about the issue of parental alienation. I would invite you to give some thought to reading in conjunction with this an article written for the April newsletter. It appears on the Dean's Court website and identifies in more detail the analysis around the recent case law and principles underpinning this issue. The starting point in respect of parental alienation is somewhat obviously to try and identify what it is. And in fact, that is where the difficulties begin with parental alienation. There is no one uniform definition. The definition that appears on your screen is the definition provided by CAFCAS. And for those of you that are unfamiliar with parental alienation or have lay clients that are seeking to understand the issue in more detail, I would suggest that the CAFCAS website is in fact a very useful starting point. I particularly wish to draw attention to the following line within this definition, which is alienating behaviours present themselves on a spectrum with varying impact on individual children, which requires a nuanced and holistic assessment. And that nuanced assessment often comes in the form of expert assessment, which will be an area that is considered within this seminar. At all times where parental alienation is a feature of a case you are dealing with, you should have in your mind the question as to whether it is appropriate for there to be an appointment of a 16/4 guardian. It is very clear that within the list of guidance regarding circumstances which may justify making a child a party to private law proceedings, that issues around parental alienation fall squarely as within the list of considerations as to whether that might be necessary. So it's something that I at this stage would say is something to be kept under active review, although it's not right that every single case in which parental alienation is a feature requires the appointment of a guardian. I would implore people to have a look at the President's 2018 speech. It's interesting because I think it sets the scene in recent years for what is a bit of a change in the approach to parental alienation, and particularly the approach in terms of transfer of residence. Those two are often intimately connected to one another, of course. In that speech, the President comments that there is actually more of a link than perhaps has previously been acknowledged between high-end private law disputes in which parental alienation is a feature and adoption. And by doing that, he's drawing a clear comparison in terms of the impact of severing a child's relationship with their parent. Following on from that speech is the case of Riel. I'm aware that most of you will be well familiar with this case, and I will not rehearse the facts within this seminar, simply to identify that that case provides, in my view, a very useful summary of the relevant applicable law. That might be a useful starting point if, for example, you are drafting a skeleton argument. It also raises two points of importance. First of all, in terms of a transfer of residence, the overriding consideration of the court is the welfare of the child. It marks a move away from the idea that such a transfer is a last resort for a court. And it also identifies that it is perfectly acceptable for the guardian to express what the ascertainable wishes and feelings are of the child, and that it is quite right that in cases where parental alienation is a feature, speaking directly to the child may not be possible. In this seminar, I'm going to focus on the bottom three cases, Re A and the two Re F cases. I draw to your attention T and Re H. They raise in particular at the point of, particularly Re H, of the importance of having good expert assessment to underpin findings of the court that parental alienation is a feature, and also to identify specialist intervention that may need to take place thereafter. I would draw your attention to T, parental alienation, as having useful annexes to it, one of which is a summary of relevant case law, the other is a transition plan where a child is changing residence. So they may form useful documents if you have cases where there are similar issues. So on to Re A. Some may consider this to be a strange starting point because this is a circuit judge level case, and the judge is Judge Wildblood. I identify this because it is a cautionary tale of a failed transfer of residence, and what the judge helpfully does in this case is he goes back and looks retrospectively at what has gone wrong. That's not a process that we necessarily do enough of in the family division. The case was exceptional in that it involved proceedings spanning 8 years, including about 36 court appearances and the involvement of about 10 professionals. The proceedings concluded with the local authority seeking to withdraw its public law proceedings, the transfer of residence having catastrophically failed, and the children ultimately returning to the care of the mother with no contact with the father. So it is a bleak conclusion to protracted proceedings. At paragraph 13, Judge Wildblood identifies 10 factors that he says he thinks have contributed to the difficulties encountered in the case. Now, those are not official guidance, but they are useful, in my view, when looking at your own case in identifying what needs to happen now and what the consequences are of not acting quickly. There is quite a lot of focus, and some of this, of course, is with the value of hindsight, in a failure to identify the key issues in respect of parental alienation at an early stage, and a failure to intervene at that point. His view is that by the time that issue is identified, the damage has been done. I'm afraid that is a familiar pattern, in my view, in cases of this nature. I think it draws to my attention, certainly, the importance of avoiding what I will describe as creeping delay. The idea that there are multiple adjournments for short review to try something out, see if it works, try something out, see if it works. Often a multitude of second chances which aren't really based in any evidence to suggest they are any more likely to work than any of the chances that have gone before. That's useful if you are in a case at the moment where you think you're at that stage, because the question has to be whether that further delay is aggravating matters. In a case where the non-resident parent is not having any contact, I think it is likely to say that it is aggravating matters. This judge highlights quite fairly the limitations on the use of indirect contact. If indirect contact, in terms of for the purposes particularly of reintroduction of a child to a non-resident parent with whom they are not currently having contact, is not done well, it can be another way in which the parent who is exhibiting alienating behaviours further alienates the child from the other parent. It's quite right to identify that in this case the letters and cards were being shared with the children by the mother, and the mother was using them as another opportunity to demonise the father. If you have a guardian appointed in the proceedings, it might be appropriate that the guardian facilitates indirect contact. If the local authority are involved, even on a lower level of child protection or child in need, it may again be that a social worker assists in that process. There was also a delay in joining the children to the proceedings. There was a failure of professionals to work collaboratively, and there were difficulties in approaching the expressed wishes and feelings of the children in the alienating environment, which is a point, of course, which is raised by Riel. The second case I wish to discuss is a case which appears in the public law arena. This is a case from earlier in the year. It's a case which concerns two children aged 11 and 4. The public law proceedings within which Mrs Justice Knowles are involved are, of course, the proceedings begin as private law proceedings. The local authority's case was that the children had suffered or were likely to suffer significant emotional harm, and that was arising from false allegations against each of the fathers of the children of sexual and physical abuse, and that the mother went to extreme lengths to create video footage of the children, which she purported was evidence of them alleging sexual and physical abuse. There was concern within the local authority that the mother's behaviour may be an example of parental alienation. But Knowles J. quite scathingly observes that the local authority is ill-equipped to grapple with complex private law proceedings where there are allegations of abuse made by one parent against another. This judge takes the view that this is not a case of classic parental alienation, but does provide some guidance at paragraph 21 for professionals working with complex private law disputes, which I am displaying the first part of on the screen at the moment. For me, some of the areas which particularly struck a chord were the repeated Section 47 investigations, which are ultimately of little benefit. It's important to identify, when local authorities are involved, what you are seeking them to address and who you think they need to speak to and which evidence they may need to consider as part of their investigations. It's quite right, as Knowles comments at part B of her guidance, that respect needs to be given to professionals who are working with the family on a regular basis, but it is also important that the local authority is pointed in that direction. If you have a case in which the local authority do not appear to be taking matters seriously, or you do not feel are appropriately supporting your client, I would refer you to point D. Families should be referred to sources of guidance and support. So that is something to bear in mind. The final points are the consideration of mediation services. If there are features of domestic abuse in your case, it is obviously the case that mediation is not going to be appropriate. But mediation at an early stage can alleviate a lot of the key issues. And it's right that often, as we all know, court proceedings aggravate rather than ameliorate these kind of issues. Again, delay in terms of expert assessments is damaging. There needs to be specialist expert assessment in many of these cases. If it is a key issue in the case, that needs to be identified early, and that expert needs to be enlisted to support. I think that the point at G is very fair. These can be some of the most frustrating and difficult cases to work because of the high levels of entrenched parental conflict into which children are inevitably drawn. Better training about these issues is required. And I think you need to bear in mind when working with local authorities that some local authorities have better training and understanding of these issues than others. Finally, I turn to the case of Re-S. It's a fascinating case about parental alienation in which a cult is a feature. If you haven't already read it, I would urge you to do so. It's a really interesting read and raises other complex points which may be matters that you have not given any thought to previously. Certainly, it wasn't something I had given a huge amount of thought to. The key issue is the mother's involvement with the universal medicine, a socially harmful cult as defined by the Supreme Court of New South Wales in 2019, and its subsequent impact on the welfare of the child. It gives a definition of parental alienation, which is interesting. I think that's quite right. It's the process that matters, not the motive. So that is quite a useful phrase, I think. I can imagine may have some value in a skeleton argument or position statement. There was no appointment of a 16-4 guardian in this case, but there was the involvement of a very experienced ISW. The Court of Appeal reaches a very unusual decision in that this case concludes with, whilst the findings are that the child is being harmed by virtue of the mother's involvement in this cult, the court allows the case to be remitted with a period of time for the mother to essentially reflect on her position and reconsider. It is interesting because there are cases, for example, where I can imagine issues around sexual abuse findings that you would perhaps want there to be, where they had been found to be false, where you may wish for a period of reflection and to see whether that assists prior to pursuing a transfer of residence. I appreciate that I've given a very brief summary of that last case, but I am keen to keep this short and sweet. As I say, there is further information in relation to this area of the law within the article published in April of this year.